So today we are going to go through a very important topic for my online students. Apologies for that. There was an announcement I have to make. We have an individual assessment system here at Prospect IAS, based on which we try to understand at what level your preparation is going on, what are the good aspects, what are the aspects that we need to take care of. So we have on our own IAS system, individual assessment system. So very soon you will get that form, and based on that it will help us and the experts to prepare a report which will be delivered to you, or you will be addressed through that report. And that is important that you go through it, and it will help us in understanding at what level your preparation is going on, because we are almost 3 months in the course, and perhaps every 3 months we are going to have this like a chronological order. Today I'm going to address a very significant matter as far as this UPSC is concerned, and they are connected. So one is judicial review. Then connected with judicial review is idea of judicial activism. We are going to understand these two aspects in a connected manner, judicial activism. And through this we can link your public interest litigation. And there is no point in going into too much detail of a definition, but you will have one. Sometimes for some people, instead of referring to the term known as public interest litigation, they refer to the term social action litigation. Social action litigation. If we look at UPSC refers to both the terms. If you look from the perspective of role of judiciary in governance, then definitely social action litigation is a better terminology. More than this, if we combine these two together, we are able to understand a significant role played by judiciary in the polity. Role of judiciary in Indian polity. Number one. Then, as you add it, get it down in the governance. This is attached to it. If you combine these two, we get what is known as judiciary and thriving democracy. Thriving democracy. UPSC has asked a question using these terminologies. Right, it is not asking you very old questions. That is why relying on online material or any study material which is available is not going to help you. That's why classroom becomes important, and I want all of you to take active participation in the classes. Somewhere in between, I want to begin with what we have let, is that the power of Supreme Court to do complete justice. And it is attached with these two. So it's not like it is not attached, rather it is very much attached with this issue. To do complete justice, one. If we add these elements here, we have how it has interpreted the constitution. We also have through this connection of the idea of basic structure. And I want all of you to make these points in your copy as well, like a map. Whatever that is coming on the board, just have your page in the landscape mode and just make like this. Wherever I am writing, I want all of you to write in your copy and page as well. Then, what is known as extending the fundamental freedom, if I use a term of polity, we get the idea of extending the fundamental freedoms, or let's say enhancing as well. Enhancing and extending the fundamental freedoms. So now we are moving ahead of discourse of rights. We are bringing in the idea of freedom, which goes beyond rights. Then, in this only comes the idea of constitutional state apparatus. Constitutional state apparatus. And one more thing attached with each of them, let's have it. So not just constitutional state apparatus or enhancing and extending the fundamental freedoms, the Supreme Court through these mechanisms has ensured a transformation in its jurisdiction. Okay, so the idea of jurisdiction has also changed. So something about jurisdiction. All right. Now if I focus on this term known as constitution here, it has gone through a very transformative change, and UPSC asks the questions from here, the idea of transformative constitutionalism. Transformative constitutionalism. So this is how UPSC is asking questions, and we have to go through these things in detail through some pointers. I will help you all in that, don't worry about it. If I have to look back at a traditional polity framework, then definitely this aspect, if you look at constitution and we focus on this term review, then as far as the constitution is concerned, it is only used in context of review of judgment and orders made by the court. Okay, review of judgment and orders made by Supreme Court. And if I bring in original jurisdiction, or let's say under Article 139A, transfer of certain cases to the Supreme Court and appellate jurisdiction, then the idea of reviewing extends, isn't it? If I bring in these two elements, so let's say in addition to this, I bring in, let's say, Article 39A, transfer of certain cases to Supreme Court, or we bring in idea of appeal, and what we discussed yesterday, Article 136, special appeal cases, then the meaning of review extends, isn't it, as far as judicial part is concerned. Now let me add something more here. So this is coming from judicial apparatus. Here we don't have anything about your executive or legislature. Now if we bring in Article 13, laws inconsistent with or in violation of fundamental right shall be null and void to the extent of violation, isn't it? That's what that article is all about. What is it? Simple. Laws inconsistent with fundamental rights shall be declared null and void to the extent of, let's say, inconsistency in simple terms. This gives the Supreme Court the right to review any law made by the Parliament. But here, as you can see, this word is not used, isn't it? They are not using the word review here. That is why, as far as our court is concerned, we come with the idea that review is not as such in case of judiciary and parliament relation. But essentially, it means that the court can review, that the court can look into the matters that are discussed and tabled in the parliament and then passed as a law. The court can review the constitutionality of every law, isn't it? So what it means essentially, court can review the constitutionality of every law passed by parliament. So let's say that the court has been able to derive this power of judicial review as it is found in American Constitution. Madison and Marbury is a famous case. Everyone keeps on repeating that name. If we move a bit further and I bring in Article 21, nobody shall be deprived of their right to life and personal liberty except by authority of law and procedure established by law. So it is actually helping here an idea of, let's say, procedure established by law. Supreme Court has over the years extended the meaning of the term procedure. It has expanded its meaning, or let's say a very transformative interpretation of the term procedure. All right, following so far? Any doubt so far? Following it? Following the logic and the structure? Everyone out there and here? Following? Good. Board chota padne laga. I have to write more on this. If I add, let's say here, if I bring in Article 32, which is about enforcement of fundamental rights through provision of writs, legal orders, then the Supreme Court here is going to use the term in a generic sense, is going to review acts of executive and judicial officers, or officers acting in capacity as a judicial authority, both way round. Okay, so by writs also there is an element and a method to protect and enforce fundamental rights. Here also Supreme Court is actively participating in the governance. Now, if you bring this with Article 142 here, which is the power and right of Supreme Court to do complete justice, then we get an idea how all of this, so from here this part to this part, if I have to make a green marker, let me use this, has actually helped in judicial activism. If you bring all of this together, this is what you have to understand, this larger backdrop. And the moment you are able to frame this picture in your mind, you can counter and answer any question. What has Parliament done? How has court done it? That's not a matter of concern. Rather, you must have this picture in the mind. Everyone has noted it down in their copy in this form? No? Write it down. Good, Manjot. People who have not written, please write it down. And then give the heading Judiciary 4. And after that, start writing. First, finish this or take a picture. Those who are here, just capture it. Immediately, fast. We're running out of time. Yeah. So write in your copy Judiciary and start writing. And start like this. Judicial review. Judicial review, comma, public interest, oblique, dash, this oblique, slash, social action, litigation, and judicial activism are interconnected. Full stop. In the Indian Constitution, the term review is mentioned in Supreme Court's in the clause dealing with Supreme Court's authority, in the clause dealing with Supreme Court's authority to review any judgment, or order passed by it. Full stop. With time, the court has democratized the application of articles conferring different jurisdictions and special powers, to ensure that the democracy in India is thriving. Bracket में write UPSC main. Democracy in India is thriving. In bracket write UPSC main. Take a pause and listen. So there are some other articles as well, like Article 226 and all of that. I'm not mentioning it today because we are not dealing with high courts. But even the high courts use these powers, right? The high court has also taken an active part in judicial activism. So that's why I'm not referring to it today. But when we will be discussing high court, then we can add that article. So now write through Article 13, right, through Article 13, in bracket write Judiciary and Parliament, in bracket write Judiciary and Parliament, comma 32, in bracket write Judiciary and Executive, comma other courts, comma officers acting in judicial capacity, officers acting in judicial capacity, bracket close, comma Article 21, in bracket write right to life and personal liberty, in bracket write right to life and personal liberty, comma procedure established by law, comma authority of law, comma rule of law, bracket close, comma Article 136, within bracket write special appeal, comma Article 141, within bracket write law declared, and underline the word declared, law declared by Supreme Court, comma Article 142, in bracket write complete justice, comma judicial idea of basic structure, comma, and no, just write are some tools through which judiciary has been able to fulfill this task of activism. Full stop. Right. One final statement. Any understanding of this issue, requires to develop a thorough understanding about interpretation of the Constitution, by the judiciary, comma, how it has enhanced and strengthened how it has enhanced and strengthened fundamental freedom, comma, democratized its doors, and write dash and write this term demosprudence, full stop, and then write like in underline format, write this: judicial review and judicial activism has radically transformed the character of Indian judiciary, full stop. It has made the Supreme Court of India into a Supreme Court for disadvantaged Indians, a Supreme Court for disadvantaged Indians, and has transformed the Indian Constitution into a living document, to complete the task of social revolution, as envisaged. Yesterday also I referred to this word, as envisaged by the framers. As envisaged by the framers, full stop. This paragraph is like an answer. Okay, so whatever you are writing, I'm trying to ensure that you understand how you have to write. It must be short, it must be crisp, but full of arguments. And each and every statement should give clear analysis, that you understand the matter, that you have this intellectual depth which UPSC is expecting from all of you. Alright, everyone has written it? ये सुंदर सा बोर्ड मिटा दे थोड़ी देर के लिए, चलिए. Okay. Alright. Let's move forward. So we begin with this idea of law declared by Supreme Court. Then we discuss power to do complete justice. Then we enter the domain of judicial review. Then some cases. Then judicial activism. And all of that. So in the next two classes it will be done. And I will discuss a main examination question which was asked. So that question and the language of that question is telling that UPSC has changed the method of asking questions. So it will help us in that regard as well. Alright. Right, next heading, law declared by Supreme Court. Law declared by Supreme Court to be binding on all courts. Article 141. Law declared by Supreme Court to be binding on all courts. Now it's very simple. So if you think in terms of, let's say, how judiciary interprets the constitution, and if you recall a little bit from the preamble class and the basic structure class, which we had, it's available on the LMS. I hope some of you have gone through, the new students. If you have not gone through, go through it. So there are usually there are many parts in a judgment. If have you seen a judgment in your life? कभी किसी ने judgment देखा है? It's like a PhD thesis. इतना मोटा होता है. And judges are saying this is the matter, this is how it is done, and then they will bring in, okay, this is what constitution has to say. Then they come with their own universe. There is a judicial universe. So they go through American judgments, they go through Australian court's judgment or German court's judgment. They were like, okay, the similar case, that judiciary did this. Because the entire modern state apparatus is connected. है ना, जिसे आप liberal democracy बोलते हैं. So the term is called liberal democracy. So this is how it is expanded. If you think in terms of polity, to get a depth here, just think like this. So you have a polity, also known as Raj Vyavastha or entire structure. To make it more simple, there is something called the state, which is a political institution, and then it is legitimate. It is not based on simple brutal exercise of power. It is legitimate. And this political institution has other features. So there is a territory, there is a government, there is population, there is sovereignty. This is how we have discussed it so far. It is sovereign. Then this government here is also referred as the administrative apparatus of the state. So क्या बोलते हैं? Administrative apparatus of state. 18th and 19th century it developed. Before that there were other kind of state. There was a feudal state in Europe. There was a polity of estates in Europe. There were emperors, शासक हुआ करते थे, Raja and Shahenshah. There were feudal lords, hierarchy of lord system. Now this apparatus of state has three organs. We have covered it. So we have one known as legislature, executive and judiciary. If you look across the world, don't you find the same structure? Do you think that any other country is lacking this kind of structure? If you look across the world, we find a similarity. That is why the judiciary here is able to refer to other, and I am using this term, liberal democracy. So what it means, that this government, which is earlier it was known only as the executive, must be made accountable. And one of the method of accountability is through election process, that people who are going to be ruled, they must elect the rulers. So there is elections and the idea of democracy. And every individual is connected here. That's why we bring in liberal democracy. The term here means like this in a very simple sense. So judiciary is able to look back across all the judicial universe to arrive at a conclusion and delivers a judgment. Now in that judgment by the judiciary, there are many parts. So there are many parts. And if you look at the parts, one is known as, to be very simple, obiter dicta. Have you ever heard this term? One is known as obiter dicta. So for example, the best example here is in the Golaknath case, in the Sajjan Singh case. In both the cases, the parliament's power was not like, it was definitely challenged to some extent, but judiciary had not taken a very radical stand. Or let's say in the A.K. Gopalan case or case before the Keswananda Bharati cases, in many cases judiciary was passing many arguments. And then while having those arguments, for example in the Sajjan Singh case, a judge said that preamble is a very important part. But that statement was not part of the judgment. It was just a statement by the judge. Those statements have no precedental value. Think like this. So these statements cannot become a precedent. So when you refer to the term law declared, we are not referring to this. We are not referring to obiter dicta. We are only referring to what is known as ratio decidendi. This is what it means here. So suppose UPSC asks you a question. What is the meaning of declared? Just go through this. This is what it means. Those part of judgment that have a precedental value, that in the future they will be referred as the benchmark. that the court has decided in this case and this law means this, not the obiter dicta. So just write this. Write Article 141, law declared by Supreme Court, law declared by Supreme Court to be binding on all courts. This is the heading. And then write first point, while interpreting the Constitution, while interpreting the Constitution, and thereby thereby delivering the judgment, judges refer to different sources from the judicial universe, created across different liberal democratic polities, full stop. Second point, there are different parts of a judgment. Next point, or in the previous point write dash obiter dicta, comma ratio decidendi. There are different parts of a judgment dash obiter dicta, comma ratio decidendi. These two words, obiter dicta and ratio decidendi. Write the third point. Kya chuta Manjot? Just drop the message. Meanwhile, write the third point. It is only the ratio decidendi. That has a precedental value. Alright, abhi ye likho Manjot, I will repeat that. Different resources, I will repeat it, don't worry. That has precedental value under the term declared in this article. Full stop. Obiter dicta has no precedental value. Manjot, write the first point. Different sources from the judicial universe, created across multiple liberal democratic polities. Okay, so this is one part of law binding on other courts. Now, if I merge Article 13, Article 136, Article 141 and what we are about to read next, Article 142, we get one more element in it. We can merge these articles together. Just keep this in the backdrop, which is known as judiciary taking part in construction of law by interpreting the law. Okay, this is how you have to keep this topic in mind. judiciary taking part in, and always write constructing in single inverted comma, constructing law while interpreting the law. Okay, this is, we will discuss it post article 142. Just keep this in the backdrop. Alright, let's move on to next article. Article 142, power of Supreme Court to do complete justice. Now this article is very important from the current affairs perspective. How many of you were able to go back and search about the case of Prince Javeer Singh? Tell me honestly. I had asked all of you to search about this case. How many of you were able to do this? You did not? Nobody did this? प्रिंस जयवीर सिंह का मामला नहीं देखा किसी ने? ओके, ये देखना है. Just go back and look at this matter. Okay, because this is important as far as your preparation is concerned. So I want all of you, please don't take any homework in a non-serious manner. Just do it. So what is, we will first go through the article and then I will discuss it, how to understand this article, because from the main examination perspective and idea of judicial activism, this has become relevant. So what is this article all about and what is the meaning of complete justice here? If you recall previous class on article 136, it has these words na, eradicating injustice, likha hua hai na, corrective jurisdiction, to rectify the wrongs done by the judiciary, all of that. And then there is this idea of writs and everything coming in, which we have covered in the fundamental rights part. But this article gives more power. So this is how the constitution is structured here. If I look at the Indian constitution, I am able to understand few things and I want to share all of you that. So through across my training in this polity and apparatus, something I have understood about the constitution. So there is something known as the constitution, and this constitution has different kind of articles. So if I have to give you about polity per se, so one method of understanding constitution is going through every article and parts. Okay, this is one. Now if you recall the first lecture, the very first lecture, that the constitution determines the form of government or the nature of state. The question came limited government. So let's bring here form of government and let's say nature of state apparatus. Both are connected. Let's bring this together. Keep writing. Don't let your pen stop for a while. Your teacher is also writing everything what he is telling here. Now, this method is helpful only for, let's say, 30% of all polity questions. If I bring pre and main together, you only look at articles and parts and schedules, blah blah blah. Rest of the 70% comes with a merger, that you look at the nuance, the details. And what happens? Some articles talk to a particular organ in a comparatively more substantive manner. So for example, if you think about article 13, it is talking to judiciary more and parliament less. है ना? This article 13, it's talking to, let's say, judiciary more. It has upper hand and parliament has a lower hand. Similarly, if I bring in article 32 here, then of course judiciary has an upper hand and parliament, let's say executive authority or officers acting in judicial capacity or have a lower say in it. It is talking to judiciary more. If I also bring in article 21, definitely it is talking to judiciary and executive authority less. Because definitely if you go for a textual reading, it is talking to the executive authority, those who are going to arrest a person and deprive that person of their right to life and personal liberty. Definitely the article is telling a procedure, how to do it. But whether or not they have done and actually gone through a legal procedure and a constitutional procedure, that entire onus is upon the judiciary. So this article is, even though talking to both the organs of the government, but it is talking to judiciary more, right? Similarly, if you look at judicial or the articles about judiciary, then these articles, article 136, article 141, article 142, they are talking to judiciary and especially Supreme Court in a very substantive manner. You should see these articles like this. Now let's try to figure out what this article is all about. Have you been able to understand the meaning, like how we have to figure it out? Like I can also give you one more example. It's a very good example. This question was asked in a company secretary exam, but this question is of UPSC level: instrumentality and functionality of the state, difference, agency and instrumentality. So let's think about article 12. It tells about state. It tells about state, what is a state, etc., etc., and you go through this approach. But the moment you bring article 12 under part 3, which is about fundamental rights, come forward if you all want to. Easy. If you think about article 12 part 3, fundamental rights, then again it is talking to judiciary more and other organs less, because it is talking about that these, whatever that is state in this, shall not act against fundamental rights. So this is how you have to understand it. Wherever the term state is mentioned, definitely empirically it refers to executive and parliamentary authorities, but the moment you situate it under part 3 and article 32 comes in, article 21 comes in, and rest all the articles come in, and these articles come in, that moment this article is talking more to judiciary and less to parliament. This is how you have to read the constitution. Whenever you're looking at polity from a UPSC perspective, keep these small thoughts in mind. Now what happened here? In article 142, the first question that must pop on your mind is that why do you need to have this separate article? Are these not enough? You have article 13, you have article 32, we have all the appeal section, then we also have a special appeal, then law declared by Supreme Court, then review of judgments. But why this article again? What is left out? And this is perhaps the manner in which Supreme Court has expanded the horizon of article 142. This is how you have to understand it. Because if they have to frame a question for next year, they could frame a question on it, because the current affair issue is right about this article. The Supreme Court has in the judgment used article 142 to do justice for Jaibir Singh. We will go through that in a brief manner for your 250 words. First, let's look at the core aspect of this article. Break to nahi chahiye abhi? Huh? Not tired na? Interested? Interested or bored? Okay, this person is interested here. This is also interested. Sehwaj is all into कि नहीं आज सब कुछ लिख लेना है, एक point नहीं छोड़ना है. हाँ? Okay, let's move forward. So the article says, in the exercise of its jurisdiction, first thing is Supreme Court, while exercising jurisdiction, and read the words of Constitution carefully. In the exercise of its jurisdiction, the Supreme Court may pass such a decree or order, may pass such a decree which is a legal basis or order or any other constitutional order, both, such a decree or order as may be necessary. I will dictate it, don't worry. Such a decree or order as may be necessary for doing complete justice. So what is the objective here? Objective is for doing complete justice. And then there is a limitation here. For doing complete justice in any suit or matter pending before it. In any suit or matter pending before it. Now always keep in mind that this article is coming after the jurisdiction. Original jurisdiction is done, appellate jurisdiction is done. Article 139A is also done, where Supreme Court can transfer cases from High Court or transfer it among them. So it is this entire topic or this entire word here, before it, must be read carefully. Its meaning is vast. It is also coming after 136. Supreme Court, and in that article Supreme Court has said it can take recourse to multiple methods to eradicate injustice. Remember last class? It can take recourse to multiple methods to eradicate injustice. So this entire statement must be read carefully. Now what this article says further, that when this order and decree is passed, it shall be enforceable. What? Enforceable. And there are different methods to enforce it. So for example, it shall be made enforceable if there is any law made by the parliament. So for example, one is that there could be a law, or a parliament can make a law, and if these two are not present, then there is a third method as well, that the president can pass an order. So order by the president. Okay, first you write this, what I have written on the board, write it down. Write article 142, power to do complete justice. Article 142, power to do complete justice. The entire name of article is different, but it is known in parlance and judicial language as power to do complete justice. So I am following this, power to do complete justice. And at the first point, we write some articles in the Constitution, some articles in the Constitution speak or address one organ of the government, substantially in comparison to the other. Substantially in comparison to the other. And I hope you have gone through it, so I am not going to repeat it. Keep this for understanding. Right, second point, Article 142, Article 142 confers the power of doing complete justice, confers the power of doing complete justice to the Supreme Court, of doing complete justice to the Supreme Court in any cause or matter pending before it. Pending before it. Full stop. Right. Third point. The Supreme Court can pass a decree or an order, to do complete justice, in any suit or matter pending before it. In any suit or matter pending before it. Full stop. It shall be made enforceable. By law, made in this behalf, by the Parliament, or if this course is not available, by an order of the President. All right. Let me इसको मिटा देते हैं अभी के लिए. Okay. So we keep this on the board just for your general understanding, and we further open this up and write one more argument, one more statement, that Article 142 is important for the exam, and dash Prince Jaibir Singh case. Prince Jaibir Singh case. Keep this in mind. Important for the exam, Prince Jaibir Singh case. Now what this article is all about. So you have gone through the subject matter of the article. You've gone through it. Let's say this is the subject matter of the article. This is it. Now if you open this article a bit further, first thing which comes specifically from reading the article is that it provides unfettered jurisdiction. Why I am saying this? So read the words carefully. Complete justice in any suit or matter. There is any before it, any cause. Alright. It can be enforceable through any way. So it provides unfettered jurisdiction. It is not limited. Any cause or matter or suit pending before it. That's how the Constitution is writing this. So there is unfettered jurisdiction. Not only this, with time the court has given it a balanced approach. Let's go like this. So there is a balance here. And this balance differentiates Article 142 from Article 136. So there is a difference here, which must be kept in mind whenever you are reading judiciary from the perspective of UPSC and the main examination. So what is this? Definitely it's an unfettered jurisdiction, which is essentially, again, if we go for the similarity, so both the articles are of extraordinary nature, extraordinary jurisdiction, both articles. But again there is a difference, we will come to it. Why I am saying extraordinary? Under the circumstances of ordinary law, there are other methods available to a person to have justice. So let's compare ordinary and extraordinary. So O and E. So in O we have Article 32. Then we have all the appeals here. These are ordinary law and circumstances. But the moment we read Article 136, special leave, appeal case, and Article 142, complete justice. O is ordinary law, is extraordinary situation. So the moment you go through this difference between different kind of clauses in the constitution, here you have ordinary circumstance, and under ordinary circumstance you can go for Article 32 and you can go for appeal, right? But when these pathways are closed, or when these pathways are not sufficient enough, then the court has a discretion here. Now again see, is there anywhere like Article 136 anything about the petitioner, that someone can reach court for this? Definitely they can reach court, but it is coming top down. The court can interfere and enter in any cause or matter pending before it. So again there is element of some kind of discretion, that the court is acting on its own behalf, and the court has made it clear that this discretion is not based on sympathy. Okay, or application of this Article 142 here is not based on sympathy. It is not based on that. It is based on pure constitutional grounds. Whether or not constitution is giving this power, then only the court will think about certain matter under the purview of Article 142. So it is based on constitutional grounds. Following so far? Any doubt? किसी को भी? समझ आ रहा है अभी? The court through numerous judgments, because if they are going to ask not following, okay, no doubt पे no sir लिखा है, मुझे लगा लिख दिया not following no sir, ये क्या हो गया, इतने ध्यान से पढ़ा रहे हैं, थोड़ा तो follow होना चाहिए. Anyways, court through other judgments has given something more in it. So because it is extraordinary and it provides unfettered jurisdiction, the court has said that this Supreme Court shall use this article with trust and caution. So it should be used with trust and caution. It cannot be used in a ridiculous or reckless manner. It cannot be used in that sense. Not only this, if you go with a bit detail, unlike Article 136, which has a supremacy over other statutes or legal provisions that we discussed yesterday, because in that article there is a statement notwithstanding anything in this chapter or part, right? In the part of this chapter 1. So unlike this article, Article 142 is a bit limited. It has to be balanced with other provisions of constitution. But in this also, while balancing, the moment we talk about ordinary law, let's say made by parliament or state governments, or some statutes, acts of parliament. When these elements will come, this article and the directions given can override. But it has to be balanced with the provision of constitution, the core of the constitution. It has to be balanced with that. And then one final thing in this article, which is perhaps very significant for understanding this article, in my opinion, in my personal opinion. If you think about Article 136 and 141, they have a precedental value, right? For example, Article 136, any judgment rendered under that article will have a binding nature. It will become a referring point for the future judgments. Similarly, Article 141, law declared by Supreme Court, has a precedental value, which we just read here. But Article 142 is only about directions. It doesn't have the similar kind of precedental value. So write next heading, nature of power to do complete justice. Nature of power to do complete justice. Number 1. Like Article 136, Article 142 vests, V-E-S-T-S, vests Supreme Court with extraordinary and unfettered jurisdiction. Extraordinary and unfettered jurisdiction. Full stop. It means that this power, should be used with utmost care and caution. Should be used with utmost care, UTMOST, care and caution. Full stop. Right. Second point. It is discretionary in nature. It is discretionary in nature. There are no limits regarding cause or circumstances. There are no limits regarding cause or circumstances in application of this power by the Supreme Court. In application of this power by the Supreme Court. Full stop. Right. Third point. With time, the court has transformed, and underline this now, this supplementary provision has transformed this supplementary provision into a substantive source of power. Into a substantive source of power. Full stop. It is next point, it is complementary. It is complementary to powers emerging from other statutes. It is complementary to powers emerging from other statutes, but not limited to them. Not limited to them. Full stop. This power exists independently. This power exists independently. Full stop. Right, next point. The major objective of Article 142 is to ensure rule of law, comma, and here you will be thinking ki what kind of controversial statement I am making, but write due process of law. Due process of law, and in bracket write under the constitutional provision of procedure established by law. Under the constitutional provision of procedure established by law, comma, bracket close, comma, doing complete justice while administering justice according to the law. While administering justice according to the law. Full stop. Right, next point. Supreme Court has restricted its powers as well. Supreme Court has restricted its powers as well. Full stop. Though this power is broad, but it cannot be exercised against a fundamental right. Full stop. This power must be balanced. And utilized in harmony with other statutes. Right, next point. No, write into this only. Next point. The court has limited the powers of legislature. The court has limited the powers of legislature constitutionally through Article 142. And write sub points in this point. Okay, write first sub point. Number 1, no law, and in bracket write enactment. Write this word, enactment. act, no law, in bracket write these two words, enactment act, made by the legislature can limit or restrict, can limit or restrict the power of Supreme Court, the power of Supreme Court under Article 142. Under Article 142. Right, next point, within next sub point, ordinary law cannot prohibit the power to do complete justice. Third sub point, write like this: though Article 142 cannot prohibit statutory provisions, but it acquires primacy as primacy over them as statutory provisions are secondary and subservient to constitutional provisions, full stop. Write next point and write as a separate point. So sub points are finished. Write a separate point. Article 142 is like Article 136, a plenary and residuary source of power. A plenary and residuary source of power. Okay? Done? Full stop. 6 is a plenary and residuary source of power. Now let's try to understand what is the matter of Prince Jaibir Singh, and how court has interpreted it, so that you have at least 3 or 4 statements with you in your notes, and whenever you read article in Indian Express or Hindu, you are able to relate to it. Okay? Are you tired or can we continue? I will take the audience poll. So those who are digitally connected need a break or can we continue? यहाँ पर तो सब लोग डर के मारे नहीं बोल रहे हैं. We can continue. One person has said. Okay, let's do this thing. So take a 4 minutes break. My clock it is 6:31. So yeah, 6:35. Okay, come back. 6:35. So what has happened in this case, Prince Jaibir Singh case, is current relevant, is very important, and perhaps one of the significant issues that you must keep in mind. So there is an idea of justice here, this term, and you have a issue of admission to a higher educational institution. Now what comes out from the judgment is that Supreme Court invoked this article to explain what Constitution tries to say whenever Constitution is talking about justice. And that gives us some understanding of what we have gone through this and how justice is referred to in the Indian Constitution. So if you are able to link, or if you are able to recall anything from classes on preamble and DPSP, and also fundamental right, especially right to equality. If we bring all of these together, so we get an idea of justice and welfare. Okay, so the question was, one is idea of welfare and idea of justice. What has come out that Supreme Court referred to, so the case is something like this: because of this person's birth in a particular caste, and due to that the person was systematically excluded, the person doesn't belong to a good background materially and financially both, and due to some bureaucratic requirements, so you must fill your form at this date, you must take admission by this date, the person was unable to enter into the education institution. And the court said, the court actually expanded the meaning of Article 14. So Article 14 is like both. You have equality before law and equal protection of law. And then this entire idea of complete justice. Now the term law here can be read through different lenses. One method of understanding is what is written. But the moment you have this term protection, society enters in. How society enters in? Think like this. First question, who needs to be protected? This is a good question to ask. From whom? From whom you need to be protected? So who is the perpetrator, let's say? How? Protection word includes this. Why? Why the person needs to be protected? There are many questions. And the moment we start interpreting Constitution like this, we no more rely on what is written. We go deep into what is the essence of the Constitution. है ना? What is the essence of the Constitution? The moment we think from this perspective, and if we consider preamble as the introductory statement of the Constitution, that preamble contains all those vision, right? The objective, isn't it? The goals. We bring DPSP, goals and objective become further clear. So now if law has to protect, we are getting some kind of meaning here. In fundamental rights, with 14, if I bring in Article 15, non-discrimination, then we get further understanding of meaning of protection. Non-discrimination. Discrimination can happen in multiple ways. One is, let's say, explicit. So for example, someone comes to my class, I look at the person, and in my mind I am like, I am not going to allow anybody who is not wearing white shirt in my class, and I say out. That's explicit discrimination, right in front. Or I can go and become more cunning. I will not say that you're not wearing white, that's why you're not allowed. I will just poke a question. I know that this person will get provoked, then I will provoke that person, and then that person will misbehave, and then I will say get out of the class. So through my cunningness, I used my cunningness to let that person go out of the class, and I discriminated. Now there is another method of discrimination which involves, so one was explicit, the other was implicit. So tacit way, let's say tacit method. Now think like this: if our laws, if our institutions are not sensitive to how people are facing unjust circumstances, let me bring in your UPSC paper GS4, that you need to have empathy and compassion in you. You need to have compassion towards weaker section of the population. That is what UPSC is expecting from you. If I bring that argument in and I bring it here because court did that, the court in this matter of Jaibir Singh said that following a strict rule which has no space for seeing how people at different rungs of the hierarchy, people who are deep down below, people who are not able, you are actually doing discrimination. And what is discrimination happening here? The idea of justice in this case, keeping this in the backdrop, is of two kinds. One is that there must be equal opportunities. So they are talking about equalizing opportunity. Article 15, 14, DPSP, preamble and fundamental right. One idea is equalizing opportunities. Everyone should be able to get opportunity. And if some old rational method of dates and etc., which are not sensitive to the disadvantaged population, are becoming a hurdle in allowing that person to enter the educational institution, that is denial of justice. That is going to be discriminatory. And therefore the court interfered. And the court said, get this person admission, we are going to do complete justice here. Unfettered, extraordinary, residuary source of power, plenary source of power. Okay. So write a paragraph here. Write. So by writing also you will understand more. Write article 142. Article 142 and current issue of Jaibir Singh, and we just have to write a paragraph. Okay, write like this. Indian Constitution has set up an obligation towards ensuring social justice. An obligation towards ensuring social justice. Full stop. This obligation is enshrined. This obligation is enshrined in the preamble. Enshrined is E-N-S-H-R-I-N-E-D, enshrined in the preamble, comma, fundamental rights, especially right to equality, comma, directive principles of state policy. Directive principles of state policy. Full stop. Write this. Fundamental rights and DPSP are the conscience of the Constitution. Are the conscience of the Constitution. The nature, full stop, the nature of rights, the nature of rights present in these two parts, present in these two parts, clearly outline the difference between formal and substantive equality. Formal and substantive equality. Full stop. Complete justice is about moving ahead from formal to substantive equality. Formal to substantive equality. It, full stop, it puts responsibility upon the state to ensure the latter. LATTER. It puts responsibility upon the state to ensure the latter. Full stop. The Supreme Court, by invoking Article 142, ensured complete justice in matter of Jaibir Singh. Full stop. The court followed a socially contextual reading of the law, a socially contextual reading of the law and procedure regarding admission in the higher education institution. Regarding admission in the higher education institution. Full stop. The court declared that not being sensitive or being into a state of oblivion, regarding the condition of socially disadvantaged, can lead to discrimination and injustice. Full stop. Through this order, the court has made a significant step, has taken a significant step towards social inclusion, towards social inclusion of the disadvantaged. Full stop. And then write one final argument about Article 142. Okay, just give a point 136, 141, 142. Write these three articles 136, 141, 142 and give a dash. Write Article 136 and 141. Article 136 and 141 are precedental in nature, full stop. They carry the force, of binding, full stop, whereas Article 142 is of directional value only. Article 142 is of directional value only, full stop. Okay, so this was Article 142 and I hope now you all have understood how these articles are working. Your notes are looking good, I hope so. Okay, इसको मिटा दें, खत्म करें इसको, दिमाग थकने लगा है आप लोगों का. All right, let's move forward. ये मंजोत, ये सर दिमाग थकने पे लिखा है कि मिटाने पे लिखा है? चलिए, let's move forward and now we begin with idea of judicial review. हाँ, इसको मिटा देते. गुड, अभी मत थकना भाई, अभी पढ़ना है थोड़ा सा और. अभी कहाँ, अभी तो बचा है थोड़ा टाइम, हमारे पास काफी टाइम बचा है. Okay, so now we are entering judicial review and judicial activism. दोनों को एक साथ कोशिश करते हैं साइड बाय साइड समझने का और समझाने का. Let's go with this. So what is this term all about? पहले तो ये इतना हंगामा क्यों है बरपा? So if you think about judicial review, basically it means that the judiciary can review. So what judiciary is going to review? Whether this particular act is based on constitution or not, right? Whether the judgment passed by the judiciary previously was right or wrong, corrective jurisdiction, as you understood in the last class, Avinash, na? Whether there is some serious concern of application of rule of law or not, whether it is following or under the basic structure or not, or is particular law or particular action against the basic structure, whether this particular action is against fundamental rights or not. So review is basically that judiciary is going to check the validity and constitutionality of any law, right, or any other action. And there are different methods. I have repeated it again and again. Article 13, Article 139 is there, review of judgments by the Supreme Court. For high courts we have Article 226 of writs. Article 32 is for the Supreme Court. So this is one, judicial review. Let's put it here. So if you have to go for a keyword, basically what we are getting here is checking the validity and constitutionality of any law or action. Let's go like this, law or executive action. Let's focus on law only. Because law itself is a wide word. When we try to figure out this term known as judicial activism, sometimes there is a word also known as judicial populism and judicial overreach. And often many people who look at judiciary, they say that sometimes court is unable to forget this difference between judicial activism, judicial populism and judicial overreach. Whereas there are some who argue that no, the court is well aware about these things. The court is always thinking that no, I should always be in the limits of constitution. If you have to think in terms of me, the court has maintained a very fine balance, in my opinion. It's my personal opinion. The court has maintained a fine balance. The court has always looked for its own space. So there are certain matters where court has not interfered. And when it has interfered, the court has not followed a strict method of abrogating the sovereignty of the parliament. So even when we refer to the restricted or limited phase of court, or let's say a very conservative working of the court during initial years of Indian Republic, when there were land reform laws being passed and they were put in the 9th schedule and the court was always arguing. So because of court and court's interference, these acts were put in the 9th schedule, that they will be outside the judicial review of the court. So when we look from that perspective, many people say that there was a court was following a very conservative approach, but recent new things have come, and even during that time court was not interfering with the larger purpose of land reforms. Court was looking for procedural irregularity. So instead of being a conservative institution, court was just finding out its own space. This is established fact now. You must update yourself with new facts. Then 1975 and especially 1979 onwards. So see, things have changed. Now think about Indian democracy like this. Just imagine about Indian democracy. Let me have a very important mark here. So we have, let's say, 1950 and we have a constitution. Then we have after 1950 a leader, a very charismatic leader known as Nehru, Jawaharlal Nehru. So we have a Nehruvian phase here. And Nehru is constantly arguing with court to respect the sovereignty of the parliament. So court must respect the sovereignty of parliament. Now why Nehru is able to say this? Because Nehru was part of Constituent Assembly as well, and that Constituent Assembly, of which he and many other leaders were part of the Congress, they had created the constitution, and out of that constitution they had created the legislature and the judiciary. And now Nehru is acting as the prime minister, so now he is a leader in the legislature, but he is always in this tussle that we know why we created you. We were the Constituent Assembly, even though we are now acting as parliament. So respect the sovereignty of parliament. And the court is going through a different argument. Court is saying, no, at that time you were Constituent Assembly. Now you have to respect the constitution. So you have to respect the space of court and parliament both. So there is a tussle going on, and the 9th schedule, entire thing comes here. Then we move further with time. After Nehru we have Indira Gandhi as the leader. Let's put her name here. So when you look at Indira Gandhi, you can think about court in two ways. One is when Indira Gandhi is following, let's say, nationalization of banks, let's say abolition of privy purses, right? These two primarily. This is one method of understanding Indira Gandhi. There is another method, emergency. Here, unlike Nehru, The idea is not to respect the sovereignty of parliament, the idea is to have a committed judiciary. What do you have here? Committed judiciary. And as you can see, UPSC asked a question about thriving democracy. So I have to give this larger picture in your mind. You have democracy here, you also have democracy here. But the moment this committed judiciary comes in, now the democracy is crumbling. Now it is shattered, huh? Because there is no more a custodian of the constitution. The custodian of the constitution should be committed. So Indira Gandhi government is expecting from the judiciary to listen to parliament. What the parliament has to say about the constitution, whereas the constitution is what the justices say it in polity. What is constitution in polity? What the judges say or what the justices say. So there is a tussle going on, there is a fight going on. Now if you think about post-emergency, this post-emergency period has seen what is known as the explosive judicial activism. This is the post-emergency. You get a very straightforward judicial review. It was here as well, judicial review here as well. But here the judicial review gets attached with judicial activism. That the court is suddenly post-emergency is acquiring a new character. And then if you think about 1990s, let's say post-liberalization, these things have become further strong and the court has acquired a very democratic character, or what is known as demosprudence. Demosprudence, jurisprudence for democracy, known as demosprudence. This is how you have to understand this entire topic, with this big picture in the backdrop. So think like this. Let me read this question to all of you, and then you will understand how UPSC is expecting from you to argue or think. So this is the question. So starting from inventing the basic structure doctrine, so we have basic structure doctrine starting from here. So UPSC is saying it started from here, and then the question reads, the judiciary has played a highly proactive role in ensuring that India develops into a thriving democracy. So from this time, judiciary has played a role. That India develops into a thriving democracy. TD. This is the first part of the question. And then the question writes, in the light of the statement, okay, in the light of this statement, evaluate the role played by judicial activism. Evaluate the role. Now this is the statement. Now you have to evaluate the role. Evaluate the role played by judicial activism in achieving the ideals of democracy. In achieving the ideals of democracy. Is this an easy question? What is your honest understanding? Is this an easy question? This is 2014 question. Not at all. I agree with all of you. Do you think that mere reading of articles can help you answer this question? Any of you? That mere you read entire articles, you have gone through the bulky books, green cover books, and you will answer this question. Let me say one more, let me read one more question. It's a simple question. The Supreme Court of India keeps a check on arbitrary power of the Parliament in amending the Constitution. This is kind of basic structure. Discuss critically. The Supreme Court of India keeps a check on arbitrary power of the Parliament in amending the Constitution. Discuss critically. So remember, always remember this. Even though you all will be part of the government, if I think in terms of polity, where are you going to be employed? So this is your state, this is your government. So you have legislature, executive, judiciary. You are going to be the part of executive, na? But see how UPSC is asking you question. It's an autonomous body to some extent, to a large extent. So they are not going to ask you questions that just give a very pro approach to the government only. You have to be very, very careful and balanced, and you need to maintain order. And order can only be maintained when you are aware about every aspect of any issue. That's what makes a good bureaucrat. That the bureaucrat is not only aware about the pros of the government policy, but also the limits of the government policy. I will not use the term cons. Limits of the policy where further growth is needed. So focus on this topic, and entire articles or whatever lectures I am taking, I have these questions in mind. So this is how, like again, resorting to ordinances has always raised concern on violation of the spirit of separations of power doctrine. So whenever ordinances are used, that is to some extent violating the principle of separation of powers. The executive is maintaining in a different manner. They are actually law making. While noting the rationales justifying the power to promulgate ordinances, analyze whether the court on this issue has facilitated resorting to this power. Now you have to critically analyze the court this time. And then it says, in the light of statement, should the power to promulgate ordinances be repealed? Should the ordinance making power be repealed? So UPSC is asking you very difficult questions with time. And these questions are not easy. And that is why mere reliance on a particular textbook which gives you a lot of information is not going to help. Especially for topics like judiciary and federalism and center-state relation and other parts. Okay. So what we are going to have today and the next class, we are going to finish judiciary in 6 modules. All these 6 classes are connected. When you will be reading your notes, you will figure it out. You have been writing every day around 6 to 7 pages. So this makes around 42 pages. It's like a 50-page document. What else do you want from me? In the class only. Let's begin. So we keep this question in mind. In the pre-question, very simple question came. Which judge is connected with judicial activism? Justice P. N. Bhagwati. Everybody knows that. Simple question. But the main examination, we have this. So the division that I have made here, let me tell something about this division and then we move forward. So whenever a constitution is, there are many ways to understand a constitution. One is that you only understand constitution as a text. Wow. Sukh gaya bichara. You only understand constitution as a text. But whenever parliament amends the constitution, and if those amendments are, let's say, very landmark. So for example, if I bring in 1973, before that amendment, all those amendments that were landmark, and on those amendments, if judiciary comes with a very landmark judgment, that is considered as the birth of a new constitution within the old constitution. So from now on, the constitution's meaning has changed. Not the structure, but the meaning. For example, if you think about Keshwanand Bharati judgment, from where we have the idea of basic structure coming in. Before Keshwanand Bharati judgment, there was no idea of basic structure per se in the constitutional interpretation. The judges were interpreting the constitution by looking at the clauses, thinking about parliament's power. They were following a very textual approach. Sorry, but from 1973 onwards, what started happening? The judges declared that this constitution has an essence, and that essence cannot be altered. It has to be sustained and protected. So that was like a birth of a new constitution within our old constitution, giving it new meaning. If you think about Indian democracy and the ideals of democracy, this is how the constitution is actually developed. We had a text, then there was a Nehruvian phase, the new constitution was coming from the old, then you have an Indira Gandhi phase, meanwhile you have a Keshwanand Bharati judgment by the court, then you have post-emergency era, new meaning to the constitution. From here onward, the constitution became a living document. This is how you have to figure out how to understand the role of judiciary. Different moments, different constitutional provisions and meaning given to the constitutional articles. If we think in terms of judicial review, let's go with old facts. We go with some facts today and then we add more values later. So basically, through judicial review, the court tries to check the validity and constitutionality of any law. Now what it means that there are certain parameters. Now if you focus on this word, as I mentioned, review word is present in one article, review of judgment and order by the Supreme Court. But this review must always be, as far as Parliament and executive action is concerned, must be within the larger idea of procedure established by law. Now what it means? Unlike the system prevalent in United States, which is based on due process of law, here we have procedure established by law. Now what the due process of law is all about, and in connection with judicial review. So Madison versus Marbury is a famous case, and it means that here, instead of looking at the procedure as mentioned in the constitution, the court comes through logic of law and legislation. So the court analyzes whether the entire action by the parliament or executive action is under the larger logical ground or universe of law or not, or is it against the principles of law. Okay, so this word here has more or added meaning, and you have to figure out which example. The best example is United States of America. Madison and Marbury is the case. Unlike this method, Indian constitution is about procedure established by law. Now what this means and how it is guiding the process of judicial review as well as judicial activism, both. Basically it means that the court analyzes whether or not the parliament and executive action was based on procedures mentioned in the constitution. First, mentioned in the constitution. Now there are different methods to derive the meaning of procedure here. So I will give you an example which you have read. One example, think about in terms of passing of ordinary bills. You have gone through this article, how ordinary bills can be passed. Very simple. Tell me if I am wrong. An ordinary bill can be introduced in either house of parliament, yes or no? Right or wrong? Okay. When it is presented or put into table of one house of parliament, it goes through 3 readings, yes or no? Right? It can be suggested to a committee as well, yes or no? Okay. If we move forward, when one house passes the bill, it goes to the other house, yes or no? Right? In the other house, it goes through comparatively the same stage, usually in a general sense, yes or no? Right? Okay. Now the other house has many options. First option is to accept the bill as it was presented to it by the first house, right? Second option is to not to give assent to the bill, keep it with itself. Third option is to send it back to the first house with some suggestions, right? If both the house agree on the suggestions, then it is sent to the president, yes or no? If the president gives assent to the bill becomes an law. This is how an ordinary bill is passed, right? In money bill, things will change. In constituent amendment bills, things will change. So, following the procedure, this is how it happens. There could be one more example. Think about Article 20, 21 and 22. When I taught these articles, I said there is a connection between these articles because they are about deprivation of certain rights and protection in that. So for example, अगर आपका दुर्गति हो जाता है, if something bad happens, suppose you people are going to be detained under preventive detention, or there is someone coming to detain you, then within 24 hours you should be presented before a magistrate, yes or no? Very simple. Those 24 hours do not include the transport wala time from reaching one place to another. ऐसा कुछ है उसमें clause, right? And then the court has said that magistrate, if possible, should be a judicial magistrate, right? So this is one way of looking at procedure. Now let's complicate it, because this is what happened in the Menka Gandhi case, from where procedure established by law expanded the meaning of judicial review and started the phase of judicial activism in a different sense. So what happens here? Now think like this. If every procedure is followed and then a person is deprived of her right to life and personal liberty, then there is a problem here. Why? Because when we are only looking at procedures from a very narrow angle, we are looking from the perspective of the state or the executive action, and we are not looking from the perspective of the constitution, right? So there is a difference here and try to understand this difference. I will try to simplify it. One thing is known as, let's say, political state. And there is one thing known as constitutional state. This difference will become more clear after the end of judicial activism topic. I have to introduce it here. Now, if everything is followed and a person is deprived of their personal life, right to life and personal liberty, and the court says yes, every procedure was followed, done, it means that we are reading the constitution from the perspective of government only, and we are not reading the constitution from the perspective of constitution. Article 21 is part of fundamental rights. Way back I have taught all of you that it is not giving right to state, it is giving protection to citizens. This is what happened in the Menka Gandhi case, and Justice P.N. Bhagwati delivered a statement, a very radical statement, and he said, the constitution is not asking us to have more procedures. This is what he said. Let me write here. The constitution is not expecting from us to have more procedures. Rather, the Constitution is expecting procedure to mean much more. Do you get the difference? It is expecting the procedure to mean more. This is Justice P.N. Bhagwati delivering judgment in the Menka Gandhi case, a passport case. And when Justice P.N. Bhagwati expanded the meaning of procedure, this procedure established by law, its essence changed. Now the court was not going to think about procedure in a narrow form only. Rather, the procedure has to be value laden. It needs to be constitutional in essence, which means it should not be against the basic structure. It means that the procedure could be legal and yet against constitutional values and morality. GS paper 4 question, UPSC has asked this question as well. So it could be legal and yet in contravention or in opposition to constitutional values or morality. That is why the procedure established by law, the meaning has changed. Now the procedure means something more, and law here means the Constitution, which means preamble, fundamental rights, DPSP, separation of power, to some extent balanced power sharing, etc., etc. And then from here onwards, from this case, the procedure established by law with expanded meaning of procedure, value laden, constitution in essence, it has given strength to the entire structure of judicial review and judicial activism in India. Initial concept cleared? How things have developed? Huh? Write one final paragraph and then we meet in the next class. Write judicial review and judicial activism. For 10 minutes you have to write judicial review and judicial activism. Start like this. Through judicial review and judicial activism, the Supreme Court has helped Indian polity in achieving the high ideals of democracy. The high ideals of democracy. Full stop. The term review is mentioned in context. The term review is mentioned in context of Supreme Court reviewing orders and judgments passed by itself. Full stop. Article 13 confers Supreme Court the power to review any law made by Parliament and declare it unconstitutional and declare it unconstitutional to the extent it violates fundamental rights. Full stop. Article 32 gives Supreme Court the power to enforce fundamental rights by reviewing the acts of executive, officials acting in judicial capacity, and judiciary. Right, next paragraph. Judicial review means that the court or judiciary, you can also write that the judiciary can check the validity, legality, and constitutionality of any law. Made by the Parliament. Full stop. The above mentioned articles, especially Article 13, gives the court this power. Full stop. Through judicial review, the court plays the role of, protector of fundamental rights, and guardian of the Constitution. Right, next paragraph. Objectives of judicial review. Write this heading, objectives of judicial review. Very simple. Number 1 point, write supremacy of the Constitution. To maintain supremacy of the Constitution. Right, second, maintaining the balanced federal setup, as enshrined in the Constitution. Balanced federal setup as enshrined in the Constitution. Right, third, protecting fundamental rights. And in sum total, if you bring all these together, write fourth, ensuring rule of law. Do you want to write more? Can we write one more thing? 7:31. Write for 4 more minutes. Write Parliament and Judicial Review. Just one last thing we write and then I stop. Write Parliament and Judicial Review. Write the first statement. The power of judicial review can be used regarding law made by Parliament. The power of judicial review can be used against, not right, against law made by Parliament, or a person can challenge, or a person can challenge law made by Parliament, in court on these grounds especially. Number 1, violation of fundamental rights. Number 1, violation of fundamental rights. Number 2, legislature has made law outside its jurisdiction. Legislature has made law outside its jurisdiction. Number 3, the law so made is against the idea of separation of power, oblique division of power, as mentioned in Indian Constitution, is against separation of power, oblique division of power, as mentioned in Indian Constitution. And number 4, it is against the basic nature or essence of the Indian Constitution. It is against the basic nature or essence of the Indian Constitution. I think that's enough for today. Okay, so in the next class we carry on with this, we go through some cases and we try to answer the question that UPSC has asked, a difficult question. Okay, alright. Meanwhile you can also try writing it yourself. I'm not going to stop you. Thank you very much for being such a patient class and listening to me talking all the time. Thank you. Okay, bye. You can send your doubts as well. I can address in next class.